Good morning, good afternoon and good night learners. Let's learn the law, civil justice and tort law. Unit 2 Bringing cases to court. This unit explores what happens before cases are brought to court and why many crimes are never prosecuted at all. Unit 1 explained that the Police and Crown Prosecution Service, CPS, work together to bring most cases before the criminal courts. This unit will look at that process in more detail. Which cases are detected, and how. Which offenders are prosecuted in court, and what alternatives are used to keep cases out of court. Bringing cases to court. The outcome of a case depends upon choices made by investigators and prosecutors long before it reaches court. By the time a defendant appears in a magistrate's court, the police and the CPS have already made a series of decisions. This section begins with an overview of the process as a whole. The subsequent sections look at key parts of it in more detail. Unit 1 considered the distinction between real and regulatory crimes, and identified bodies other than the police and CPS who can investigate and prosecute crimes. This unit will focus on real crimes investigated by the police and prosecuted by the CPS. Decisions made by the police and prosecutors at these early stages affect the whole of the court process. If they are not fair and appropriate, the outcome of the case could be unjust and may therefore lead to a miscarriage of justice. It is not surprising, then, that the actions and decisions of police and prosecutors at each stage can be controversial. For example, do some investigative techniques, such as undercover policing, unjustifiably invade people's privacy? Are all sections of society treated fairly? These concerns are not new. In 1820, the British economy was struggling. There were food shortages and high unemployment. People were campaigning for the right to vote, then limited to male landowners. The previous year, soldiers had killed 11 protesters in the Peterloo massacre. The government responded by passing acts to suppress further protests. Angered by this, a group of men met in a small loft in Cato Street, London. They plotted to kill the leading members of the government, the cabinet, and take over London. However, they were arrested before they could carry out the plan. 5 of them were executed for their part in the conspiracy. The main evidence against the defendants came from a government spy who had infiltrated the group and suggested the attack on the cabinet. He did not give evidence. Instead, 2 of the conspirators did, in exchange for the charges against them being dropped. One of the conspirators, William Davidson, was of mixed black and white heritage. He denied the charges, but there was strong evidence against him and he was convicted. He tried unsuccessfully to argue against a death sentence and told the court, "You may suppose that because I am a man of color I am without any understanding or feeling and would act the brute. I am not one of that sort." The judge responded, "You may rest most perfectly assured that with respect to the color of your countenance, no prejudice either has or will exist in any part of this court against you." The question of whether the criminal courts are really without prejudice remains important today. The police. The police usually deal with the earliest stages of the criminal justice process. They make decisions even before some crimes are identified. For example, which crimes should they focus upon detecting? What methods should they use to detect those crimes? Where or on whom should they focus their attention? Other crimes are reported to the police by the victim or another concerned person. Again, the police will have to make decisions, such as: is the incident actually a crime? If so, should they investigate it? If so, how will they investigate it? When an investigation does indicate that a crime has probably been committed, the police decide what the next step should be. They may choose to deal with less serious offenses without using legal proceedings, for example by issuing a fixed penalty or caution. The Crown Prosecution Service. If the police consider that court proceedings are appropriate, then for less serious offenses they will begin court proceedings, usually by charging the defendant at the police station or by postal charge, a written charge and postal requisition. For more serious offenses the next step is to consult with the CPS. The CPS may decide that further evidence is needed in order to make a decision that no further action is appropriate or that the case should go to court. If it does recommend a prosecution, it will also advise on the appropriate offense. Suspect: a person suspected of a crime during a police investigation. Defendant: a person who has been formally accused of a crime, e.g. by charge, postal charge or summons. After a suspect is charged with an offense, the CPS will be responsible for bringing and making decisions about the prosecution. The police will assist the CPS with witnesses and evidence, and the officers involved in the investigation are likely to be witnesses themselves. Detecting crime. Most crimes do not come to the attention of the police, and many of those reported will not result in further action. This section considers the reasons why people may choose not to report a crime, as well as why they may do so. It also considers how the police gather evidence both of crimes reported to them and of offending that has not been reported. When the police make choices about which crimes to investigate and how, they are responding to a wide range of factors. Many of these are controversial. Reporting crime. One of the most important ways in which crimes come to the attention of the police is by members of the public reporting them, at the time of the incident or later. However, many crimes are not reported. In the year ending March 2020, it is estimated that over 10 million crimes were committed, but the police only recorded 5.8 million crimes. Office for National Statistics, 2020. The decision to report. Victims or witnesses to a crime may have a lot to consider when they decide whether to report a crime. Many of the reasons which discourage people from reporting crime are connected to discrimination and disadvantage in wider society. For example, ethnic minority people are more likely to have had negative experiences of the police, as Section 6 will explore. They may fear for themselves or others if the police become involved, or may simply not trust the police. One reason many people report thefts and burglaries is to get a crime number for their insurance claim, but someone experiencing poverty is much less likely to insure their possessions. They may also think a crime is too minor to report, e.g., a low-value theft, even if its effect on them is not. Many minority groups are more likely to experience crime than the population as a whole. However, they may be concerned that the prejudices motivating such crimes could be shared by people in the criminal justice system. They might also have other concerns. For example, some LGBT victims of crime may fear being outed, as court proceedings are public and can be reported in the news. A victim's story. Some crimes are particularly underreported, including sexual offenses and domestic abuse. Gathering evidence. An alleged crime may be reported to the police or discovered as a result of police actions. The police will then decide whether it requires a response. The police may decide not to record the report as a crime. For example, the alleged behavior may not be a crime, or the police may conclude that the report is not believable. The story may seem improbable, or there might be evidence which demonstrates it could not have happened. The police response to a crime will also be affected by the resources available to them. Limited funds for employing police officers and paying the other costs of investigation mean that police forces must prioritize certain types of offenses and may not be able to investigate others. While not all incidents reported to the police should be recorded as crimes, this extract from a BBC News story, BBC, 2019, raises the question of whether the police are failing to record too many reported crimes. Police forces across England and Wales have been criticised for not recording hundreds of thousands of crimes reported to them each year. Inspections of force databases have found offences, including violent and sexual ones, have not been counted towards official figures. One force, Derbyshire, was found to have not recorded about 30,300 crimes a year, more than a third of the total in its area. What is the difference between reported and recorded crime? When an offence is reported to police, officers may have investigated it fully, but it only counts towards Home Office figures if they record it as a crime. Recording crime means the police can work out where, when and how often crime is happening, as well as how to respond, what resources to put in and how to support victims. Discovering crimes. Some crimes are discovered by the police rather than reported to them. The police have powers intended to help them discover crimes, including surveillance of suspected people or premises, searches of people, vehicles or premises, e.g., stop and search, interception of communications, e.g., phone calls or emails. The extent of these powers, and the ways in which they are used, are controversial. They may be used against people who turn out not to be involved in criminal activity. The ways in which the police decide who to target are also criticized. However, without these powers, serious crimes might go undetected. How far should the police be able to invade our privacy in order to prevent and detect crime? There is no agreement on the answer. Investigating crimes. If there is an investigation, the police will have to decide on what evidence should be collected, who should be interviewed, and what other inquiries should be made. They should pursue all reasonable lines of inquiry, whether these point towards or away from the suspect. What is reasonable in each case will depend on the particular circumstances. Ministry of Justice, 2015. Sources of evidence may include victims, witnesses, the scene of the crime, physical evidence, e.g., Weapons, CCTV footage, fingerprints, DNA material. Intelligence, information from people with knowledge about the crime. The police have powers designed to enable them to collect evidence. Many of these are set out in the Police and Criminal Evidence Act 1984, PACE, including searches of suspects and buildings associated with them, detaining suspects in custody, questioning suspects, taking fingerprints, DNA and other samples, identification procedures, stop and search. The police have a general power to stop and search people and vehicles in public places. It allows a police officer to detain and search a person or vehicle if they have reasonable grounds for suspecting that they will find items such as stolen articles, weapons, or equipment for committing certain crimes, for example, a crowbar for a burglary or paint cans to damage property. Reasonable grounds for suspicion should be based upon current information or the person's behavior, not on stereotypes, appearance, or previous convictions. The Equality Act 2010, EA, makes it unlawful for police officers to discriminate on grounds including race and religion. The police also have specific stop and search powers for particular offenses or items, e.g., controlled drugs. Some of these, e.g., a power to stop and search anyone within a specific area to prevent serious violence. 2 or terrorism. 3 do not require reasonable grounds for suspicion. The controversy. Statistics show that black people and Asian men are disproportionately likely to be stopped and searched. In the year ending March 2019, there were 375,588 stop and searches in England and Wales. Almost half took place in the Metropolitan Police area in London. Only about 15% led to an arrest, although others will have resulted in outcomes such as a fixed penalty. The rate at which people were stopped and searched varied widely by ethnicity. 4 in every 1,000 white people were stopped and searched, but 38 in every 1,000 black people. Governor. UK, 2020. In other words, a black person was more than 9 times more likely than a white person to be stopped and searched. The police perspective. Many police officers consider that stop and search powers are vital to prevent serious crimes. The Metropolitan Police explains that it can avoid unnecessary arrests, as well as detecting crime and finding weapons. Why the police use stop and search? Why we use stop and search? The main reason we use stop and search is to allow officers to investigate their suspicions about an individual without having to arrest them. How effective stop and search is as much about avoiding unnecessary arrests as it is about a crime being detected. Stop and search protects the public by preventing crime, identifying offenders and building public confidence in their policing service. In 2019-20 stop and search resulted in almost 65,000 criminal acts being discovered and 34,000 arrests. This includes 4,418 arrests for possessing weapons and displays what a vital crime-fighting tool it is and how it protects the public by taking weapons off the streets. Stop and search is most effective when the police use it appropriately. The College of Policing, which sets standards for the police and shares good practice, has described the effects of stop and search on public attitudes. In general, when members of the public trust officers to make fair decisions and treat them with respect, they are more likely to see the police as legitimate. Legitimacy, in turn, encourages people to cooperate with the police and not break the law. The evidence suggests there is, in principle, public support for stop and search, provided it is used appropriately. This support is conditional on how stop and search is targeted, how it is used by officers' attitudes and the reasons they give for exercising their powers. The ability to hold the police to account may also be important for building public support. Overall, stop and search is more likely to be effective when it is used in a targeted and intelligence-led way against active offenders and when officers' grounds for suspicion are strong. 2016. The Commission's view. Stop and search has been the subject of reports and inquiries by official bodies including the Equality and Human Rights Commission, Great Britain's national equality body. Northern Ireland has a separate body, the Northern Ireland Human Rights Commission. The use of stop and search is particularly controversial in relation to its disproportionate use against ethnic minorities. The independent Lammy review was commissioned by Prime Minister David Cameron in 2016 and led by David Lammy MP. It considered the treatment of Black, Asian and minority ethnic, BAME, people throughout the criminal justice system. Its final report includes the following statistics. Despite making up just 14% of the population, BAME men and women make up 25% of prisoners, while over 40% of young people in custody are from BAME backgrounds. If our prison population reflected the makeup of England and Wales, we would have over 9,000 fewer people in prison, the equivalent of 12 average-sized prisons. There is greater disproportionality in the number of black people in prisons here than in the United States. Lamy, 2017, p. 3. It found that stop and search is contributing to a sense among many in BAME communities that the justice system is stacked against them. Among those born in England and Wales, people from ethnic minorities are less likely than those who are white to agree that the criminal justice system is fair. However, stop and search is also an important part of the police response to issues such as knife crime, which threaten people's safety and lives. The debate about stop and search is also part of another wider debate about what the limits of the criminal law should be. How does the criminal justice system balance the need to protect people's liberty with the need to protect them from harm? Keeping cases out of court. This section explores alternatives to prosecution. It begins by looking at options suitable for less serious offenses whose perpetrators have not committed similar offenses before. It then considers options for addressing antisocial behavior, ASB, which is repeated and can be difficult to prosecute effectively. Fixed penalties and cautions. The police have the power to impose a fixed penalty for some minor offenses. For other offenses, including some quite serious ones, they may decide that a caution, a formal warning, is more appropriate than court proceedings. Fixed penalties. A fixed penalty notice may be issued to adults for certain minor crimes. One example is speeding. If police officers or a traffic camera catch somebody driving above the speed limit, a fixed penalty notice can be issued. Another example is the penalty notice for disorder, PND. For a penalty of £60 or £90 is issued, and the recipient can either pay within 21 days or go to court. Payment is not an admission of guilt. For example, somebody might choose to pay rather than face the risk and inconvenience of going to court. Offenses for which a PND may be used include shoplifting, where the value is under £100. Criminal damage, where the cost of rectifying it is under £300. Being drunk and disorderly in public. Littering. Possession of cannabis for personal use. PNDs will not usually be given if the person has previously received a PND for a similar offense, or has recently received a PND any offense. Cautions. A caution is a formal warning given by the police at a police station. It can be given for any offense but is usually appropriate for less serious offending where the person has not committed a similar crime before. If they have previously been convicted of, or cautioned for, a similar offense, a caution can only be given in exceptional circumstances. Some cautions can be conditional. They include certain requirements such as receiving treatment for addiction or repairing damage. People under 18 will receive a youth caution. However, this section focuses on simple cautions. A caution is not a criminal conviction, but it will appear on the person's criminal record. In order to be cautioned, the person must admit that they committed the offense and agree to accept the caution. If they do not, then they may be charged with the offense and taken to court. Cautions are therefore a valuable way of dealing with offenses outside court. They spare the victim and witnesses the need to attend court, give the offender a warning rather than a conviction, and deal quickly with the incident. Safeguards include that there must be enough evidence for a realistic prospect of conviction if the case were to go to court, and that the offender must admit the offense and agree to be cautioned. Fixed penalty, caution or charge. For less serious offenses, the police may need to decide whether a fixed penalty or caution is more appropriate than a charge. Antisocial behavior. Antisocial behavior, ASB, is legally defined as conduct causing harassment, alarm or distress. It may include individual antisocial acts which are not criminal, but may nonetheless constitute a significant problem because they are repeated. For example, one noisy late-night party is annoying for neighbors. Repeated noisy late-night parties could significantly affect their lives. In recent decades, Parliament has created various ways of dealing with ASB other than with criminal prosecutions. These include community protection notices and ASB injunctions. Community protection notices. If a person persistently behaves in the same antisocial way, which has a detrimental effect on others' quality of life, then the police might issue a community protection notice. It requires the individual, or a business or organization, to do, or not do, specific things. If they do not obey the notice, they commit a criminal offense and may receive a fixed penalty notice or be prosecuted and fined. ASB injunctions. An ASB injunction is a court order available where a person has engaged in persistent ASB. It can prohibit them from doing certain things, e.g., playing loud music at night, or require them to do certain things, e.g., attend a drug misuse course or mediation sessions. The injunction is a civil law order, not a criminal one, so the standard of proof is the balance of probabilities, i.e., that the allegations of ASB are more likely than not to be true. In a criminal case, the prosecution would need to prove beyond reasonable doubt that the defendant had done the alleged acts. Breaches of injunctions, i.e., the perpetrator not obeying them, are common. When dealing with breaches, civil courts do not have the sentencing expertise of criminal courts, nor the power to impose community sentences. Many defendants do not receive legal advice or representation. The result is that some defendants are committed to prison for behavior which would not be punished so severely in the criminal courts. The criminal courts are not always the best places to address misbehavior. Alternatives to court include fixed penalties, formal warnings and orders. When these work well, they can be a more effective way of resolving an issue or preventing further offending. However, there are concerns that these powers are sometimes used too widely and that their consequences can be harsh. For example, cautions appear on criminal records. Breaches of ASB injunctions can lead to imprisonment. The decision to charge. The police are responsible for the earliest stages of a case. They decide whether and how to investigate, and whether to use an alternative to court proceedings or take no further action. For less serious offenses, they might also decide whether to charge the suspect. However, the police work with the CPS on decisions about whether to charge a suspect with a more serious offense, and they hand over the conduct of prosecutions to the CPS. The first decisions the CPS makes are whether a prosecution should be brought, and for what offense. Deciding to prosecute. The Code for Crown Prosecutors, Director of Public Prosecutions, 2018, sets out the principles that prosecutors must follow when making their decisions. These include being independent, fair and objective, acting in the interests of justice and protecting the rights of suspects and defendants, as well as victims. In order to decide whether a prosecution should be brought, the CPS applies a two-stage test known as the full code test. A case will only be prosecuted if both stages, the evidential test and the public interest test, are passed. The evidential test. A case will only pass the evidential test if there is sufficient evidence to provide a realistic prospect of conviction. A realistic prospect of conviction means that the likelihood of the suspect being found guilty is higher than 50%. In other words, it is more likely than not that in a trial, the prosecution will be able to prove the case against the defendant beyond reasonable doubt. To evaluate that, the prosecutor must take into account an objective assessment of the evidence, any information the suspect has put forward and any defense they might have, whether the evidence can be used in court. Remember that, as Unit 1 explained, the prosecution has the burden of proving the case against a defendant. They must prove it to the criminal standard of proof beyond reasonable doubt. If a case does not pass the evidential test, a prosecution will not be brought. The public interest test. If the evidential test is passed, then the next stage is to consider whether a prosecution will be in the public interest. The Code for Crown Prosecutors breaks this test down into 7 questions. How serious is the offense? The more serious, the more likely that prosecution is in the public interest. What is the level of culpability of the suspect? In other words, how blameworthy are they? For example, why did they take part and what was their role? What are the circumstances of, and the harm caused to, the victim? Prosecution is more likely to be in the public interest if the victim was vulnerable, or was serving the public, or the offense was motivated by prejudice. What was the suspect's age and maturity at the time of the offense? Prosecution of a young person under 18 is less likely to be in the public interest than prosecution of an adult. What is the impact on the community? Offenses may affect people other than the immediate victim. Is prosecution a proportionate response? For example, the cost of bringing a prosecution can be weighed against the likely punishment the suspect would receive. Do sources of information require protecting? A prosecution might not be in the public interest if it would expose information that would harm ongoing investigations or national security, for example. Choosing the offense. Each criminal offense has its own definition, and its own maximum sentence, as Unit 4 will discuss. When choosing which offense to charge, the prosecution must consider whether it can prove all the elements of its definition. Usually, the prosecution will have to prove that the defendant both did a wrongful act and had a blameworthy state of mind. In our case study, Shireen is suspected to have committed theft. She admits the wrongful act of taking the ring. She denies having a blameworthy state of mind for theft, dishonesty and an intention to deprive the shop of the ring because she says it was an accident. Sometimes, it is unclear what offense is most likely to have been committed. For example, in assault cases, the difference between the less serious, actual bodily harm, and more serious, grievous bodily harm, is not clearly defined, as you will discover in Unit 13. The prosecutor will not always charge the most serious offense available. They have to consider factors including the seriousness of the accused's offending and the court's sentencing powers. The maximum sentence a magistrate's court can pass is 6 months imprisonment, or a total of 1 year for 2 or more offenses. The Crown Court can impose much more severe sentences, including life imprisonment for the most serious offenses. Magistrates or Crown Court. As Unit 1 demonstrated, most cases are dealt with by magistrates' courts, but some more serious cases go to the Crown Court. Criminal offenses are divided into 3 types. Summary, either way, indictable only. Summary offenses are less serious crimes, e.g., assault and battery which does not cause injury. They are dealt with in a magistrate's court. The most serious offenses, e.g., wounding with intent to cause grievous bodily harm, are indictable only. That means they must be sent to the Crown Court for trial and sentencing. The third type of offense is called either way, because the offense can be tried in either a magistrate's court or the Crown Court. If the magistrates think the case is too serious for their court, i.e., it will require a higher sentence than they are able to pass, they will send it to the Crown Court. If the magistrates decide they can deal with the case, the defendant has a right to choose jury trial in the Crown Court. Either way offenses include assault occasioning actual bodily harm, i.e., an assault which causes actual, but not very serious, injury. Challenging the decision. As Unit 1 explained, criminal prosecutions are brought on behalf of the state, i.e., society as a whole, not the individual victim. A victim's views are only one factor taken into account when making a decision. If a victim is unhappy with a CPS decision not to prosecute, they can seek a review of it under the Victim's Right to Review scheme. The decision will be checked by a prosecutor who was not involved in the original decision. If that prosecutor decides that the decision was right, they might give the victim extra information about why it was taken. If they decide it was wrong, the CPS will if possible bring criminal proceedings. If the victim is unhappy with the review outcome, they can request an independent review. Exceptionally, a victim who remains unhappy with the review outcome might challenge it in the High Court, a process known as judicial review. Judicial review is costly and difficult, so those cases are rare. Conclusion. The CPS makes decisions about whether to prosecute using a 2-stage test. The first, evidential, test asks whether there is a realistic prospect of conviction. If there is, then the second test asks is it in the public interest for this case to be brought to court. A case will be prosecuted in court only if it passes both tests. This unit has examined the many decisions made by victims, the police and the CPS before a prosecution is brought in court. It has explored how some of those decisions are made, and criticisms of those processes. These help to explain why only a small minority of crimes result in criminal prosecutions, and illustrate that the processes are not purely objective. You have also had the opportunity to develop your academic skills by experimenting with note-taking techniques. You should now be able to describe the different stages of investigating and prosecuting crimes. Discuss key criticisms of the pre-trial process. Please like, comment and subscribe. Good morning, good afternoon and good night learners.